How are our judiciary staff? Doing well?
All right. They're good. They're good to go. Okay. All right. So I would like to just call the meeting to order. It is 12:34 on September 25th. And just start with welcome and introductions. I'm actually going to just start this by going around the room in person and having folks announce themselves and the organization that they're with or who they're representing. And then I'll start with the virtual folks.
Good afternoon, everyone. Phyllis DeCara.
I'm Joe DeTune. I'm the Director of Family Services, part of the Connecticut Judicial Branch. Good afternoon.
Good afternoon, Mary Kazicki, Judicial Branch Office of Victim Services.
Afternoon, everyone. CJ Force here from Judicial Regional Manager, Family Services.
Good afternoon, Andrea O'Connor, Family Violence Victim Advocate Program Manager for the Umbrella Center.
Good afternoon, everyone. Gail Hardy from the Office of the Chief State's Attorney.
Good afternoon, Megan Scanlon from CCADV.
Good afternoon.
Captain Ryan Maynard, Connecticut State Police.
Good afternoon, Eulalia Garcia, designee for Commissioner Quitos, Department of Correction.
Good afternoon, Johanna Canning on behalf of the Division of Public Defender Services.
All right, we have one in-person straggler at the moment. So we're gonna let her get settled. So I'll start with Merritt.
Good afternoon, Merritt LaJoy, the Complaint Officer for the Office of the Victim Advocate.
All right, Senator Flexer.
Good afternoon, everyone. My name is Mae Flexer, and I'm the State Senator for the 29th District.
Senator Kissel.
Yeah, hi, everyone. State Senator John Kissel from the 7th Senatorial District in North Central Connecticut. And I'm here in large part by virtue of the fact that I'm the ranking senator on the Judiciary Committee.
Judge Doyle.
Good afternoon, everyone. Judge Kevin Doyle. I'm assigned to the Hartford Judicial District.
Ginger.
Good afternoon. I'm Ginger Wilk. I'm the Senior Director of Reentry Services for Community Resources for Justice, Family Reentry, and we run domestic violence programs for offenders throughout the state.
Captain LaRock.
Good afternoon, everybody. Heather LaRock. I'm a captain with the Windsor Police Department.
Trooper Richmond.
Good afternoon, TSC Richmond, Connecticut State Police Training Academy.
And Miss Garcia, I think you're. Can you unmute?
Oh, I already checked in. District Administrator Garcia, designee for Commissioner Quitos with the Department of Correction. Thank you.
Yeah, we're just going around doing introductions, so thank you. Okay, I think that's everybody on Zoom. We have one in-person addition.
Good afternoon, Karen Foley O'Connor, CEO of the Network Against Domestic Abuse and retired Connecticut State Police.
Okay. All right, great. So we'll just move on to the approval of the June meeting minutes. Does anybody have any, anybody want to make a motion for the approval of the meeting minutes?
So moved.
Second?
Second.
Great. Any discussion or corrections or updates? Okay, hearing none. All in favor?
Aye.
Any opposed or abstentions?
Merritt LaJoy is abstaining. I was not present at the meeting. Thank you.
Merritt.
Mary Kazicki also abstaining. I was not present either. Thank you.
Okay. All right. Thank you. Okay. We're moving on to subcommittee reports. We're going to change up the order a little bit. We'll start with the Offender Intervention Standards report. Joe?
Good afternoon. Our subcommittee has been very busy. One of the things that we agreed as a subcommittee was to formulate a series of questions about whether agencies utilize domestic violence programming in their agency, or do they contract with anyone for domestic violence intervention or treatment? And then the other question is about if you do, does it comply with standards? And if not, why? And then the third, and probably most important, is do you know of any services in the community that that offer domestic violence interventions, or do you refer out for those? Our goal is really to hopefully get a pretty decent view of the breadth of domestic violence interventions across the state, and to kind of see how that jives with the list that we have, and also the CSSD domestic violence programming that we contract with, which does meet the standards. After we agreed and voted on those questions, my co-chair Shauna and I emailed those questions to pretty much every state agency and the judicial branch. We sent it to the chief state's attorney, the chief public defender, Department of Public Health, Department of Social Services, every state entity that we could think of. We're also going to do a 211 search and send it to those agencies. And we're also going to try to do some research like about the APA, American Psychological Association, or other larger groups that might have lists of individuals. It's going to be a heavy lift for Shauna and myself, so we were able to secure some help from an intake assistant at Court Support Services Division, who's going to help us gather all that information. And then once we put it into I don't even know what the word is, but once we figure it out, we have a list and it's in good format. We'll share it with the subcommittee, and then Shauna and I will then dig even deeper to talk to whatever agency is offering that service in the community, to talk to them about the DV standards and show them how to get on the list, and work with them to do that. So our goal is to, again, really to take a look at, how many DV intervention agencies there are that are doing batterer intervention programming, and just so that we can see where we're at relative to that. And again, that's going to take some time. Our hope is that, Shauna and I get the responses. I think we asked responses were due at the end of September. Is that true? And then, it's going to take some time for us to follow up. So hopefully by January, we'll have that list fully developed. And again, we're going to have to do a lot of work to dig down and drill deeper into those agencies. So that's our hope. Really, the idea is to see if there are these agencies that are out there that are performing these interventions that we don't know about, or that other agencies are utilizing in a way that we can see if our standards are going to fit into the really kind of how we're structured now, or if we need to make a change.
Thank you. Any questions? Comments? Points of discussion? No. I guess my follow-up question would just be, given the timeline, do you think you'll have recommendations for our December 4th meeting, or you'll have an update as to what you think the recommendations will be? Because
yeah, I mean, I'm hoping that it really depends on how quickly we get responses and how developed those answers are. I think, for Shauna and myself, we just don't know the answer. We don't know what's going to come back. So we'll have a better idea of the breadth of work we're going to need to accomplish to basically tell the committee, one, there's a lot of domestic violence interventions in the community that we just weren't aware of. And our hope is that we'll be able to tell you that we've talked to them about, signing up for the standards so that we have a much more robust list than we have now. The other hypothesis is that really there aren't many agencies doing that work, despite our best efforts of trying to dig deep and find them. If that's the outcome, then we're going to have to really take a look at how our standards are utilized in practice, and to kind of see where we go from there. So it's going to be something that I think that if we take our time and make sure that we uncover every program that we possibly can, with the help of the state agencies, we'll be able to, I think, have a good roadmap of what we're going to do next.
Okay, great. Any other questions, comments, topics of discussion from the rest of the members? Okay. I have one that has come up recently for us, and that's the supervised diversionary program. That's supposed to be reserved for people with mental health issues or veterans. And there's been some questions around eligibility and what goes into the eligibility for that program. So I didn't know if you had any insight into that, or if we could open it up for discussion amongst the entire council, because I think there's some general concerns around who is or is not receiving that program when it comes to family violence.
That's a program that CSSD Family Services does not recommend people into that program. So I think it would really, if you wanted my recommendation, I think it would be something that, Gail and Shauna and CJ and myself, and maybe Judge Doyle could have a discussion about. I'm really, frankly, not that familiar with it. I mean, I know it's in the lexicon of what happens in court, but in terms of what Family Services offers, we've never had that as part of our referral source. So I think that it would just take some discussion with CSSD, probably adult probation, who I think has after the order is made. But I think it's probably a discussion for, and maybe it's a really good discussion for the DV roundtable, which is coming up, Gail. I mean, I think that you have prosecutors, victim advocates, and family services again, but not really anything that we handle or make referrals to. And it might be a good place for, and unfortunately, but I think we have a lot of discussion in that group about some things that we're dealing with on other subcommittees.
Okay, great.
For sure.
Yeah, because we're looking at it, Gail, in terms of like how there are definitely circumstances where somebody's reoffending sometimes on the same victim and being eligible for that program multiple times. So I don't know if you have anything to add.
Shauna and I actually talked about this topic as one of our DV roundtable discussions, and we have agreed to meet on October 15th. I've already spoken with Joe about it. So in between that time, I can also find out more from our offices and our prosecutors as to whether or not they are recommending persons apply for that program, or if it's coming from a defense attorney.
I think what's happening most of the time in the GAs is that an application is made by the defendant. It's not often recommended. It is it is a program that's out there available for the defendants to apply through. And there's statutory provisions about who qualifies, who doesn't qualify. And it is a clinical decision. It's not a decision made by the court. Eventually they decide who goes into the program, but whether they are actually eligible is not made by the court. So.
Okay, that's helpful. And maybe the two of you then can connect for.
Yes, and just so I'm clear, are you saying that most often it's a pro se defendant who is just making application, or?
I wouldn't really know about the pro se's a lot. So that would be where you'd have to talk to your people, whether pro se's would be making applications. But I do know that as defense counsel, that is one of the programs that's in our pocket, that if we believe our client qualifies for, it is certainly something we would apply them for. The state has their opportunity to object if they don't think it's appropriate, and it's once eligibility is found, and then it is argued before the judge who makes the final decision.
But yeah, I think just also, you're absolutely right. There is a kind of a clinical decision component of that prior to somebody being kind of granted that program. And I think I probably piggyback what Joe says, is that once that decision is made, it is sent to CSSD probation. So I think that would probably be a good connection to have that individual who oversights that can talk about the qualifications and what happens, and what does that process go in to make them whole, to be able to then apply for, I believe, a disposition on that case, which is favorable.
I have a follow-up question. So is that a tool that you're using in every case, or is it specific cases? It's specific to the client. It's a very specific subset of persons who would be eligible, and they're clinically eligible. It depends on their mental health access, whether they're access 1 or 2 or 3. The eligibility is found outside of the court system in a clinical way. So no, it's not for every client. It's certainly, and there are certain charges that it's simply not they're not eligible for. It's similar to the accelerated pretrial rehabilitation program, but it is specifically for those who have been diagnosed with a mental illness. Okay, thank you. Any other comments, questions regarding this topic? All right, so we'll look forward to Oh, my apologies. Is that a question? No comment? Sorry. Okay, so we'll look forward to an update at the December meeting from your meeting on the 15th. That would be great. Thank you. Any other comments, questions regarding Offender Intervention Standards Subcommittee? Okay, all right. Moving back up to A, Law Enforcement Model Policy. Yeah, you're up.
So I do have copies of some changes that I'll just add we met on the Law Enforcement Model Policy met on September 3rd, the subcommittee. And at that meeting, with the departure of Dan Cargill, I was voted in as co-chair of that committee alongside Chief Fox. So we were tasked with responding to and including in the policy a process for if the highest ranking member or a chief of a police department is arrested for domestic violence. So it is on page 16 of the model policy. I have copies of page 16 and 17, and I believe Liza is emailing copies to those that are online right now. So let me take one. And I'll wait till everybody has those in hand, and I'll go over the changes once we have those in hand. So on page 16, which is the subsection 8, officer involved domestic violence incidents, you'll see the changes that are in blue. And the first change, or I shouldn't say change, I'll say addition, begins under under sworn personnel from within the law enforcement agency, that the highest ranking on-duty shift supervisor shall notify or cause to be notified the following personnel. Number 1 of that list was the chief of police. We added a bullet of, in the event of the suspected domestic violence offender is the chief of police or other administrative head of the police agency, notification shall be made to the town's chief executive officer, and that can include a mayor, town manager, town administrator, etc. And moving down further, when talking about the criminal investigation, we added the bullet, in the event that the suspected domestic violence offender is the chief of police or other administrative head of the agency, this is in regards to the criminal investigation, that it would be referred to the state's attorneys of that particular jurisdiction. And then flipping over to page 17, when discussing the fact that law enforcement are to surrender all of their law enforcement issued firearms, long arms, ammunition, tasers at the time of the arrest, that in the event of the suspected domestic violence offender is the chief of police or other administrative head of the agencies, firearms shall be surrendered to the town's chief executive officer, mayor, town manager, town administrator, and note we add their designee. That allows that chief entity to assign sworn personnel of their choosing to handle that task. And continuing down with, in that same bullet, we again added, it's the exact same bullet all the way through to administrative procedures, internal investigations, etc. These changes were made with discussion with the chief state's attorney's office. We felt we didn't want to go over our scope and guide what then has to happen from there, as this is a law enforcement model policy. And so we felt that this was the simplest way to address this concern.
Great, thank you, Karen. Any questions, comments? And just to give context, there was obviously the East Lyme case recently that prompted the review of the model policy and some of these additions to be made.
Said you made it to my morning meeting. He's like, what? I said,
Yep, thanks for muting. Thanks for muting. Sorry about that. Any comments you wanted to make, Gail, from the state's attorney's perspective?
No, Karen and I did discuss this. We went over it thoroughly. We talked about potential conflicts, and in the case of a chief of police, it would always be a conflict for the local state's attorney to investigate or to continue to prosecute that matter, in which case the police or the highest ranking police officer should also contact that local state's attorney, who in turn will be directed to contact the chief's office. So, and that's our process.
And are they going to determine what entity is going to lead the investigation in terms of law enforcement?
Yes, and
Okay.
that's an issue that we take up at the monthly state's attorneys meeting. But you know, if an issue like that arises after we've had our meeting or before we've had our meeting, the local state's attorney will reach out to the chief state's attorney to determine which state's attorney or which jurisdiction should receive that case.
Okay, great. Any questions?
Yeah, Madam Chair, a quick question, just as I'm reading that. Am I to read that if would this be subsequent to arrest of a chief of police, or would this have to be going to in the form of the state's attorney for a warrant, or how would that play out? For instance, officer goes to the chief of police's house. Is it expected that an arrest will or will not be made based on probable cause, or that will be turned over to the state's attorneys?
So you've got two scenarios here. You've got an on-site probable cause arrest, right? And then you also have the situation where someone may go to a state's attorney with an arrest warrant to ask for that arrest warrant to be signed and approved. And in that scenario, if it were the chiefs of police, it would be brought to the state's attorney, and the state's attorney's wheels of who determines the investigation would be in motion. If the arrest occurs on scene, then that highest ranking person that's on the shift from where that chief is assigned would then have to notify the town manager, head administrative leave. And again, that town manager or head can choose whatever designee they choose to continue with like like securing weapons and things of that nature that are typically done by a sworn person. Does that answer that?
Yeah, so this would not impact the probable cause of somebody showing up and making that arrest and the arraignment, all those other things following.
Nope.
Okay.
And there's two scenarios that the chief could be in the town where they actually work, or the chief could be in another town. And it does address that regardless, that whatever police department that officer is assigned to, chief or not, that PD needs to be contacted immediately to the highest ranking shift supervisor. And in this scenario, if it is a chief of police per the model policy, they now need to go to their town manager, mayor, whatever entities governing that police department within to take care of the administrative pieces, like turning over department weapons, things of that nature.
Thank you. Appreciate it.
But in any case, if it's an on-site arrest, that local police department is responsible for making the arrest. The state's attorney's office takes over after the arrest or for review of the arrest warrant.
Thank you.
Great question. Any other questions, comments? Okay, I just had one. So once the weapons are turned over to, let's say, the town manager, chief executive officer, is there going to be a best practice for those individuals that then get these weapons? Let's say I'm the town manager and are they supposed to then hand them off to state police it doesn't have to be in the model policy. It's just something I thought about in terms of what training they would need to know who the appropriate person would be to come take those weapons.
can't
Because
speak to-
obviously you don't want them in town hall or,
Yep.
yeah.
I can't speak to all police departments, but I can speak to most, including the state police. There is an armory that is at the department, and those are department issued or department owned weapons. So those would be secured at the armory. That whomever is arrested, chief or whatever, regardless of rank, they have the same 24-hour guidelines to turn over their personal firearms, and those would be secured in the vault.
Okay.
Another scenario could be if there's some kind of nexus with the crime and the handguns, then they would be secured as evidence, which would go in an evidence holding facility,
Yeah.
which is only maintained and controlled by one person or two people at that PD.
Okay, great. Thank you. Any questions from anybody? Oh, Senator Flexer, I see a hand up.
Thank you, Madam Chair. I just have one question, and I know this may be a somewhat far-fetched scenario, but I know there have been situations where the chief of police has become the acting town manager when there's a vacancy in the town manager. So I just wonder if this might need to be tweaked a little bit in the event that there's a domestic violence arrest for a chief of police who is serving in that chief administrative role.
That's a good question. We talked a little bit about when there's so we didn't actually address that. We did talk through the situation where some towns don't have their own necessarily chief. They're overseen by a state state police troop. But we should go back and look at the town manager scenario because we didn't talk that one through.
Thank you.
My only concern about is, are we going outside the breadth of what this is supposed to be a law enforcement model policy? We're kind of treading into town politics. And that I think that it's a good idea. I think we should talk about possibly adding the entity of the state police as an
Yeah,
override. for
I
that kind of
think it's
scenario.
only I think you're only talking about, Senator Flexer, the circumstance where there is a standalone police department. If the town manager is vacant, there are times where that chief is sort of doing both duties. So we might just need to do some research on that and figure out, to your point, what's in scope and what's not for the law model policy.
For the sake of discussion, I'm thinking that it might be a good idea to just simplify it and just add a bullet scenario that if the chief of police is acting as the highest town entity, that it should go to the state police barracks in that jurisdiction. And I don't know if you want me to bring that back to the committee or if you want to discuss it as a whole here.
We can discuss it as a whole, and then we certainly would have to bring it back to the committee. So any thoughts from anybody else?
So I think we're looking at a couple different things as we're talking about this too. We're talking about the immediate seizure of firearms in that instance, in that investigation. So if we could add that bullet in. I think it will ultimately be covered when it also goes to the referral piece to the state's attorney for the investigation as to how things need to move forward. I think that's part of that initial notification at the same time. Because the policy does state that we're going to seize the firearms no matter what. All we're really trying to do is remove a situation where a subordinate is potentially trying to go up against a commanding officer, or a chief. And I think we're actually covered in what we have to try and get this to move it forward so that we at least have something in place. And then even the one-off scenarios, I think, are still captured in that overall investigation piece.
Okay. So I think, so we're not looking for anybody to approve this language or anything today. We are going to clean it up, take some of the discussions. Maybe we'll just take your comments and Karen's to just make sure we've got that covered and everybody on the subcommittee is good with the language. And then we will be bringing back the final language for the December meeting, because that'll go into, so that'll be finalized and then go in to the law model policy. And then that'll be part of the recommendation that goes to the legislature, is just that update to the law model policy for January. Karen, did you want to bring up LAP at all, or our discussion around LAP? No. Okay, I'll bring it up. Okay, so we did at the subcommittee talk a little bit about LAP, and I think where that stands is that we CCDV is actively sourcing feedback from both law enforcement and advocates. The discussion that was brought up was around some of our neighboring states have proposed statutes to make LAP mandatory in their states. And so we were discussing whether or not that was something that Connecticut wanted to consider. I think the consensus was trying to find a way to put it in law, in model policy rather than a statute. So one of the questions I think we took back from the subcommittee was to really find out what the barriers have been to fully implementing LAP across departments. I know Andrea and Shauna are leading that. Andrea is getting the feedback. I think in general, I mean, we don't have all the feedback from, but like big picture, I think there is sort of a theme of just inconsistencies across the state with regard to best practice. So it may be good for the committee to kind of just see what could be put in law model policy as best practice. I don't know, Karen, if you wanted to add anything to that.
We were just discussing that because the model policy under the Family Violence Prevention Act of 2012 became minimum standard by statute. So anything that we put in here becomes minimum standard by statute. And we have a lot more freedom to control the narrative of what's happening here. And as you can see with this change with the chief situation, this model policy has been evolving since 2012. And I expect that will keep evolving as different scenarios like the senator brought up. So the thought was, let's try to get some best practices into the model policy. We can vote upon it. And then if we find a scenario that we can address, we could do it here. It's a lot easier than sending it through the legislature when we already have the ability to do that here. My thought process, because the landscape of law enforcement in Connecticut is so different from cities to small rural towns, that we keep it very bare minimum that the LAP should be done under these circumstances, and try to keep the specificity of like how each department does it kind of out of it, and just get the bare bones in there, just so we're not tying a department that doesn't have the capabilities to do certain pieces. And I bring up the piece of using a cell phone. Not officers are issued department cell phones to help the victim. They always find ways to work around it. So that was just our suggestion. I felt as a committee, we were pretty much in agreement that that was probably the better way to go. And in essence, we are legislating LAP if we do this by adding it to the model policy.
Okay, any comments, questions, concerns about LAP or exploring how to make it a minimum standard in the model policy? Okay. All right. Well, with that, I will just give a plug that we do have a training coming up because training was one of the comments that's come back for LAP. We do have one October 2nd, train the trainer. So if you have advocates or law enforcement, please have them sign up. It'll be a good opportunity for them to just get some really good skills and best practices around LAP and how to implement it. And I do want to just say like a huge thank you to law enforcement in general because this has been implemented all voluntarily across the state for many years. So kudos to all law enforcement that have been implementing it. And we're just really trying to, I think, showcase that in some ways, give them the credit where credit's due, and lift that up as a great service that they are doing for the public and public safety. So, all right, Gail. Yep.
Megan, is the Train the Trainer program at Post or your office?
It's at our CCDV office in Glastonbury. And if anybody has like questions or anything about it, Andrea, who's our new director of law enforcement services, just started a couple months ago, is going to announce that later in the meeting. You can see her after the meeting as well.
Megan, I'm sorry, one more quick question. Whose responsibility under that provision is it to notify the town manager? Is that incumbent upon the chief of police or the officer responding? Who does that become his responsibility?
It would become the highest ranking on-duty supervisor of that PD. In the first bullet talks about the notifications that
Okay.
that supervisor is to make and adds the caveat that if it's the chief of police, it doesn't go, it goes to the highest ranking person in the town.
Thank you.
All right, any other questions, comments? Okay. All right, moving on to arrest warrants and orders of protection, compliance enforcement and outcomes.
Good afternoon. Our subcommittee met twice since the last council meeting in a hybrid format. We met on August 21st and September 17th. At our August meeting, we received a presentation from Sergeant Brianna Maurice from the Connecticut State Police Special Licensing and Firearms Unit. She had a PowerPoint presentation to, first of all, discuss the responsibilities of the unit. And that includes the issuance of pistol permits and eligibility certificates. And she also explained how the unit is involved when there is a firearms purchase. Background checks, we learned, are only done at the issuance of a pistol permit or an eligibility certificate, and it lasts for 5 years. That is the only time that a background check is done, and it would be done again at the 5-year point. We learned that there are approximately 140,000 firearms transfers per year. As it relates to our victims of domestic violence, they often want to know if an offender has complied with orders to surrender firearms. That information is confidential, as is all information relating to who the holders of pistol permits or eligibility certificates are. That information is only released to law enforcement, to DEMIS, or Department of Mental Health and Addiction Services, and it is released to other states if they're contacting Connecticut to inquire as to whether or not a person is a holder of a pistol permit or eligibility certificate. We also discussed the surrender process that's involved when a person is arrested for a domestic violence crime. Her PowerPoint was really exhaustive. It prompted a robust discussion around the firearms procedure in general, and a lot of information that I was hearing for the first time. There is a PowerPoint available if this council would like to receive that PowerPoint or a presentation from Sergeant Maurice. She's available to present to us. We met on September 17th also, where we reviewed the work of this subcommittee and the numerous presentations that we received to try to help us come to some sort of agreement as to what recommendations that we are going to make to the larger council. We were supposed to have a presentation on that day from court operations regarding the issues that arise when a person is arrested for a domestic violence offense, but that person bonds out from the police department. And usually if they're bonding out from the police department, the conditions of release are set.
Laughing. And we didn't all know each other, but like it felt like we were all
are set by the police department, and we wanted to receive some sort of direction on what happens if that person fails to appear. We had a scheduling issue with court operations, so they are going to present at our October 23rd meeting. But in the course of reviewing all of the prior presentations, we voted to actually have Darren Mitchell, who presented to the larger council, to come back and to engage with us on recommendations that we can make and how to improve our system's response to domestic violence abusers' access to firearms. As I stated during our meeting, Jerry Wild and I had been discussing this issue over the years, and I'm sure that domestic violence victims and survivors want to be sure that a person who is under an order to surrender firearms has actually done so. So one of the aspects of Darren's presentation that we're really interested in is how we as a state can ensure that those people who are required to surrender are actually surrendering their firearms. There is a form, a compliance form that is filled out, and we want to be able to ensure not only that that compliance form is filled out, but that those people who are under that order are actually in compliance. And Judge Doyle brought up that you, if we were to bring this person or the accused back into court, we would be infringing on the person's Fifth Amendment constitutional right against self-incrimination if the court were to ask this person whether or not you are currently in possession of any firearms. So we definitely want to pursue this discussion so that we can move forward with victims feeling safe and knowing that the person who has an order is actually in compliance with the court's order.
Thank you. Any questions, comments? Yeah.
I brought this up previously when I sat on the governing council for the model policy. And I don't know if this is done by design, but on that conditions of release, it says one of the conditions which relates to weapons, it says may not use or possess a dangerous weapon, okay? We have a statutory definition for deadly weapon. We have a statutory definition for dangerous instrument. This word that's on this conditions of release is not a legally defined word. Are we doing that on purpose to make it sort of can be something that doesn't meet those two and with that the officer just deems a dangerous weapon? So I'm not in that group, but you mentioned the conditions of release and I've been talking about it for a long time. And I'm just wondering the thought process and I'm wondering if that presentation might help.
Yes, and I think Brianna would be able to shed some light on it, but I also recall this being a topic that we brought up when Dan was chairing the model policy. And I believe we talked about going back and changing that. I'm not sure, but I know that we discussed this previously.
Okay, that's a good question. Okay, we can do some research on that to figure out where it stood in the model policy subcommittee. Thank you. Any other questions or comments? Okay. All right. Do you have any questions or comments? No? Okay. Anybody on Zoom? No? Okay. All right. Thank you, Gail. Okay, that brings me to other business. Any other business that anybody wanted to bring up before the council? Okay, hearing none, I'll move on to, okay, I'll just move on to remind you that the next date that we meet is December 4th. That is the date that we should have final draft recommendations from all the subcommittees that we will then approve as a full council, that then will go into the report that's due to the legislature in January. So between now and then, whatever you need in terms of your subcommittee and however many times you need to meet in order to get that done, that I'll leave that up to the subcommittees to decide and schedule, but that December 4th meeting will be really presenting the final drafts of those recommendations for each subcommittee. Any questions about that? Okay, all right. Then I'll just take a motion to adjourn. Oh, I'm sorry. Actually, before we do that, I do want to introduce, I don't know if everybody was here at the last meeting or not. And I know some folks on the model policy did meet some of our staff, but I do want to introduce Andrea Deo as the new Director of Law Enforcement Services. She comes to us with years of experience in the Waterbury Police Department as a detective there. and has done a lot of great work in that community, bridging the gap between law enforcement and the communities that they serve. So we're very excited to have her on board. And then for those that have not yet met, but some of you have, Shauna is our director of legal advocacy. She took over the role that Jerry Wild held for a long time when Jerry moved into, which is now she actually moved into our chief operating officer role effective September 9th. So you'll still see her involved in the subcommittees and in the council, but she's going to be busy with some other tasks as well. So we're very excited for all of them. And then we do have an intern, a policy intern, Shannon, who, if you want to wave, Shannon is working with us for prepping for session and to look into some of our longer term policy initiatives that we want to be able to bring forth to this council and then to the legislature. So my apologies. Thank you for the reminder, Gail. With that, I'll take a motion to adjourn.
So moved.
Second,
Second.
all in favor?
Aye.
Right. All right. Thank you very much for a very efficient and effective meeting, everybody. Have a good rest of your week.